Great. Welcome everyone to our meeting of the Provisional Licensure Working Group. It is September 18th, 2020. This meeting is being recorded. I noticed that we've got a number of attendees joining, so I'm just going to wait for a few seconds while that populates. In the meantime, should we go ahead and call roll?
Okay. Tylen Chin.
Here.
Ruben Duran.
Here.
Robert Barrett.
Here.
Diane Boyer-Vine.
Here.
Julie Crisp.
Here.
Terry Garland.
Here.
Dolores Heisinger.
Here.
Jennifer Bacon-Henning.
Here.
Judge Herman.
Here.
Paul Kramer.
Here.
Cindy Panuco.
Here.
Vern Pearson. Vern Pearson. Okay. Judge Rodriguez.
Here.
Angela Sierra.
Here.
Tiffany Townend Blacknell.
Here.
And the liaisons Neil Gupta
Here.
and Greg Fortescue.
Here.
Thank you.
Great, welcome everyone. So we are meeting today for what I hope is going to be the last meeting of our working group to go over the public comments that we have received to the draft rules regarding provisional licensure. I note there are 39 attendees as members of the public, and we will have a short period of time for comments from the public. We did receive 192 very thoughtful comments about our proposal. We need to be efficient today. We've only got 90 minutes scheduled for this, and I know a number of us have things that we need to get to immediately at 11 o'clock. So we're going to need to be efficient. I want to thank all the folks who have submitted written comments for the time that you took to provide your thoughts. They will help us craft the best rules that we can for provisional licensure. And with that, I would like to open it up for public comment. Donna Hershkowitz is going to run that. I will remind folks, we have received a lot of written public comments. We urge you to not be duplicative of stuff you've already submitted and things that people will raise. If someone's already raised it before, we'd ask that you limit your comments.
Okay, with that, Devin, I think you've got the comm here. If you can open the mic for 2018 graduate and attorney. You have the mic. Once you get started, you'll have 2 minutes. Please go ahead.
Good morning, and thank you for your time to listen to our public comments today. You stated in some of the comments that the purpose of the program is to respond to those graduates who had little to no opportunity to take a bar exam prior to the pandemic. Well, we believe the purpose of the state bar is to protect the public and support of efforts for greater access to and inclusion in the legal system. I won't reiterate everything we stated regarding prior graduates. Those in my position have emailed the Supreme Court with our concerns regarding the lack of retroactivity application in light of the program, and have been expressly told by the Supreme Court to relay our concerns to the program meeting today. Thus, we don't think it's beyond the scope of this meeting. It's my understanding, based on the Supreme Court's response, that this group will be providing a recommendation to the Supreme Court, even if the Supreme Court directed the program to be administered one way at first. For this reason, I kindly ask you to please consider and fight for us in your recommendation to the Supreme Court today. Please recommend to the Supreme Court today that we are already minimally competent by virtue of obtaining the required cut score necessary, and therefore should be granted licensure under this program while waiving the bar exam requirement. Applying the provisional licensure program to graduates who have not already passed the bar exam is a slap in the face. Please stop passing the ball to one another. Thank you.
Thank you for your comments. Next, we'll turn to Matt Chipman. If you can give Matt the mic.
Hello, can you hear me?
We can, Matt. You'll have 2 minutes.
Thank you. I just wanted to raise a few issues to this committee. First, I noticed that, and I think I said it on the first meeting, but the limited practice rule that we're working on is supposed to be essentially unlimited in the practice areas, but the Supreme Court said it's supposed to be for limited practice areas. So I guess I would like to present concern that if this rule is presented to the Supreme Court and it directly conflicts with what they've asked us to do, what is the follow-up for this committee or the court? Are they essentially allowed to then reject it and rewrite it, or does it come back to this committee and the committee comes up with something new? I have concern that this sort of conflict is going to present a time delay for people who are able to take advantage of this between the back and forth between this committee and the Supreme Court. Furthermore, I noted that there's a $200 fee to use this program. I'm concerned because applicants are being told either by ExamSoft or other entities that they have to purchase new laptops to sit for the bar. And they have to hold on to these laptops for a time until the scores are released, so they can't sort of purchase and return these laptops. I'm concerned that the $200 is, just another fee that's being tacked onto this that people are going to have to bear. I know that there's a $55 fee for nonprofits, but I would just encourage this committee to consider some kind of financial hardship waiver that applicants can submit to get this fee reduced or expunged in some way. And I guess finally, though, I understand that it might be outside this committee's purview, I would just reiterate that the way that this is sort of being handled and extension the bar, I'm really just flummoxed in how all of this is going on. The bar tweeted yesterday that a mandatory deadline for submitting the exams is being pushed back. They said we're supposed to receive an email on it, and no one has received this email. So essentially, we are getting our news from the state bar regarding mandatory deadlines via Twitter. I'm very concerned that this is sort of indicative of a greater handling of these things, and that this is, I'm sorry to sort of vent my frustration right now, but this whole process has been extremely difficult to deal with for all of us who are trying to do the right thing and trying to go through all the hoops. So I'll just end it there. Thank you.
Thank you for your comment, Matt. With regard to the fee issue, we did receive 16 public comments that addressed the question of the fee, and I think that public today will see that that's something that staff have teed up for the working group to talk through again and reconsider. So that is on the agenda to talk about most certainly today. If we can turn to public commenter named Libby. Libby, you have the mic.
Hello.
Hello.
Hi, I'm calling for the resignation of Halen Chin, of both chair of the Provisional Licensing Group and a State Bar Board of Trustee. Many don't know that Chin unsuccessfully represented the UC system in their fight to continue using the SAT and the ACT as part of its admissions process, but thankfully, a judge blocked the UC system from using the SAT and the ACT as part of its admissions process, finding a test optional policy gives an unfair advantage to students who can assess testing centers during the COVID-19 pandemic. But unfortunately, in that fight, Chin said, "It's a very unusual time, and students, regardless of disability, have difficulty accessing the test, but there's not a single plaintiff who has provided actual evidence that they have not been able to access a test center and are therefore irreparably harmed." This shows that Chin does not have any grasp of reality in what law graduates and students are facing. This was evident by her actually proposing that people who are taking volunteer legal positions should pay for provisional licensing fee. But thankfully, other groups like the Legal Aid Association pushed back and said that lawyers who are trying to volunteer shouldn't have to pay for a fee. This person is a big law partner who is completely divorced from the reality, and therefore she should resign.
Donna, you're on mute.
Sorry. Next public commenter, Kathleen Beckett. Are we able to unmute Kathleen?
She's been given the mic.
Kathleen, you have the mic now?
Thank you. Yes, I observed the last PL working group meeting wherein it was considered that December 2019 graduates would possibly be extended PL regardless of their February score. I think that depriving people who have met the current threshold but graduated prior to December 2019 while providing PL to people who wholeheartedly did not meet the 1390 threshold is an unequal treatment of February examinees, and that should be a relief that's provided to everyone who took February, if February was indeed impacted, or not applied to anyone who took February. Thank you.
Thank you, Kathleen. Madam Chair, that is the end of public comment.
Great, thank you. I believe that next on the agenda is approval of the minutes. The minutes have been posted. And I think we can we take both of them at once and call for a vote on those?
Yes, we can.
Okay, are there any comments or edits to the minutes? Not seeing any. Do we have a motion for approval of the minutes for the August 7th and August 18th meetings?
So
This is Duran. I'll second.
Seems like Diane moved it and Ruben seconded it.
Yes, ma'am.
Ezra, could you call a vote, please?
Eileen Chin,
Yes.
Ruben Duran,
Yes.
Robert Barrett,
yes.
Diane Boyer-Vine,
Yes.
Julie Chris,
Yes.
Terry Garland,
Yes.
Dolores Heisinger,
Yes.
Jennifer Bacon-Henning,
Yes.
Judge Herman, Paul Kramer,
Yes.
Cindy Panuco,
Yes.
Judge Rodriguez,
Yes.
Angela Sierra,
Yes.
Tiffany Townend Blacknell.
Yes.
Okay, thank you.
And yes from Judge Herman.
Oh, okay, thank you.
Great, thank you. Okay, let's turn to the public comment. Their State Bar staff has helpfully put together a chart listing all of the public comment that have been received in writing, as well as an initial staff response. And what I propose we do is we go through the items where the staff has recommended consideration of some changes, and then we can turn to any other items this working group wants to raise. So the one where, as Donna mentioned, we received the most number of written comments was with respect to the fee. And those begin at page 4 of the comment chart, if folks want to take a look at that. A lot of comments regarding the size of the fee, the hardship that it poses, whether there could be scaling for those working for IOLTA-funded organizations, the pro bono organizations, and questions about what constitutes a volunteer.
So I would just start, Helen, by noting that I know we had considerable discussion about the fee at the last working group meeting. Staff were certainly moved by the comments that we received and thought it was appropriate for the group to sort of despite sort of the concerns that I even personally had raised at the last meeting, that, you know, we absolutely have capital outlay costs for the program, the automation, for the application process and approval process itself, to get the individuals tied into the 10-hour new attorney training. Staffing costs will likely be bringing on temporary staff to be able to process the applications quickly, and we'll have outlay for that. But nonetheless, I did, as I said, I was moved by the comments that we received and thought that it'd be appropriate for the working group to consider a further reduction to the fee. As we talked about before, one of the sort of comparator fees that's out there is the $55 fee that is charged to the certified law students, the practical training of law students program. Certainly, the provisionally licensed lawyers are have a much greater responsibility and rights to practice law than certified law students do. So, you know, that certainly could be some, you know, part of your consideration, but I wanted to sort of pass it off to the working group to think about.
And Donna, is there any amount that State Bar staff recommends? I know we struggled with this last time because I know so much of it depends on how many people actually sign up.
You know, we don't have a recommendation because we really don't know what the costs are going to be. And so, you know, my, you know, sort of my personal inclination, as I sort of struggle with this in terms of understanding the needs of the applicants, and as leadership of the State Bar and understanding our financial needs, you know, I certainly, something that we can look to is the fee for the PTLS program, that $55 fee. And we could also consider that for those who are working for IOLTA funded organizations, we could do a 25% reduction in the fee that would parallel what we do for attorney licensing fees, where if your licensing fees are paid by one of the State Bar's IOLTA funded organizations, then that then the licensing fee is reduced by 25%.
Hi, Lynn, this is Ruben. I don't know how to raise my hand on the phone only function, so.
Okay, go
If
ahead.
you could call on me. Oh, great, thanks. Donna, thank you very much for compiling having your staff compile all the public comments. And like you, I was struck by the number and the breadth of comments that centered around the financial hardship. I've had some time to think about it, and I think that this is one area where I would encourage us as a group to think about being responsive where we can. I think it's important that the bar try to cover some of these costs, but certainly given the uncertainty, it doesn't make a lot of sense in my mind to try to figure out how we could cover all the costs. The PTL program, I think, as Donna just mentioned, is much more limited in scope. And so I think it's a good benchmark to start from there and use that as sort of a comparison. Given that, and given the second piece that Donna just mentioned with the IOLTA funded organizations, if they're going to take on PLLs, I'd like to suggest that we set the fee at $100 for folks working outside of IOLTA funded organizations, and then $75 for the IOLTA funded organizations. I just put that on the table for discussion.
Great, thanks, Ruben. Diane, you have your hand raised.
All right, so I was probably the person who moved the $200 last time, and I too am struck by the comments and concern over the fee. I actually would go to I would go to Donna's kind of starting point of the $55 fee with the reduction for the IOLTA funded provisional licensees, but perhaps we should discuss Ruben's $100 first and see if we want to go that way. I'm in favor of trying to give these folks a break at this point. It sounds, I didn't realize they had to buy laptops to take the bar. So there's a lot of output they have and a lot of stress that we could help alleviate by making the fee lower.
Great, thank you. Tiffany?
Perhaps I forgot the details, but correct me if I'm wrong. They need to send in their diploma, an attorney who will be their supervisor, and apply for moral character. What other work is necessary for the bar to do exceeding the PTLS program? It seems to be pretty streamlined, similar to the current certified law student program, where they send in their proof they're enrolled in evidence, their dean send in some sort of document, I sign a document. Why isn't it the same amount, $55? I mean, I propose it be the same amount, since I don't see additional workload that's different from the certified program. I think you're right that they have additional rights and responsibilities, but in terms of the burden on the bar, I don't see it as being a more onerous task in terms of verifying their documents. And unlike the out-of-state people who have to apply, it seems to be more labor intensive, but for the folks who are taking advantage of this program, I don't see why it should be more than 55.
So one of the, I'll sort of take the first. I think Amy has more, but one of the differences is is connecting them to the work that needs to be done to connect them to the new attorney training. That's available through the My State Bar profile, the attorney's profile on our website, and the law students wouldn't be part of that website. The provisionally licensed lawyers, and so we would need to sort of develop a system to provide them access to the 10-hour training and to track that training. Amy can talk about if there's other workload on the admissions staff in processing.
So the monitoring process, as you suggested, Donna, it's about tracking the education as well as any potential vetting that's going to be required for the supervising attorney. There are requirements about the supervising attorney that they cannot be have any a discipline record and the like. And so some of that is going to require, it's more work than something like PTLS, which is more straightforward. So those are the types of monitoring and vetting that come to mind that are different for this program than they are for PTLS.
Are the attorneys that are supervising attorneys not vetted for the PTLS program? I'm sure I sign off on something that says I'm qualified. How exactly is the vetting process different?
Well, this rule is explicit about ensuring that people do not have been practicing for a specific amount of time, that they also don't have a discipline history, and I think there was one more thing in this rule that will require that we review supervising attorney differently than we do for PTLS. Because I think with PTLS, you sign off in a, we'll still need a sign off, but you sign off and we don't vet somebody's background.
It looks like Rob is next, and then Cindy has her hand raised. But let me also ask Donna and Amy, is it also the case, another difference between this and PTLS is that there are things that PTLS students don't access the way a PLL would. For example, the free ethics hotline, you know, they are subject to state bar discipline, and so that could trigger the Office of the Chief Trial Counsel's investigations process and the like, that it would pose a somewhat different burden on the state bar system than the PTLS program does.
Yeah, I believe that's absolutely right, Helen, that they would sort of as a PLL have the ability to, you know, access the ethics hotline. We've said they're subject to state bar discipline. So yes, those things are different as well, which would certainly take additional resources.
Okay, so let me turn it over to Rob and then Cindy.
I think I saw Cindy waving her hand before me, so I'll yield to her and then I'll go next.
Okay.
Yeah, I was just gonna add seconding the $55 fee for everyone. And then as my understanding is the current fee waiver for licenses for someone who wants to be licensed, you have a fee waiver application where you get 50% off if your income from all sources is under $20,000. So we could implement that for anyone who is suffering any sort of financial hardship, is trying to get licensed before they have a job. But anyone who's going to go work for a private employer, $55 fee could be something that the employer could cover, unless again, the person applies for and qualifies for this a fee waiver. And in terms of IOLTA funding, I do have to speak up for the legal aid, contingency here, that at least in the, from the legal aid perspective, if we're taking on these folks and they're volunteering, whether it be as a fellow or they're volunteering for free, they should be eligible to get a complete reduction. So I would advocate for a $55 max fee for those who are at, who end up in private employers or employers who can cover the licensing fee, and no fees for those who go and take on volunteer or fellow or jobs while they have these limited licenses at least IOLTA funded organizations.
Okay, Rob?
I'm glad I let Cindy go first. She said everything that I would say.
Okay, any other comments or discussion?
This is
Go ahead,
Angela.
Angela.
I agree with Cindy's proposal there. And I'm just wondering, that folks may be volunteering, given all the circumstances, at a number of different types of firms or organizations. So it would seem to me appropriate to have either a reduction or no fees for volunteers, regardless of the type of firm or organization.
Correct me if I'm wrong, but I think folks are not under the labor laws permitted to work in private or for-profit law firms, I think. So we might not have even encountered that problem in terms of, I don't think private firms, solo practitioners can take on volunteer labor under, I think there's been some guidance on that during the last economic crisis when firms wanted to take on volunteer attorneys. There was some guidance around, or folks awaiting bar results. There was some guidance on not being able to do that in private entities. I think they can go to government and for judges and do that, but I don't. So I think, I agree. If anyone's volunteering, it should be in compliance with the law, not at private entities or law firms. But if they're with the government or nonprofit, I agree with that.
Yeah, good point. Thank you.
Halen, my computer is not letting me lower my hand. So I don't know what to do about that. I think if I need to say something or want to say something, I'll wave at you. The only other thing I would add, now that I've taken the floor, is that I would like us to have kind of an escape hatch whereby we look at, after a certain amount of time, the amount of extra work, if there is more work for the bar, and leave ourselves the option of revisiting the cost thing if we learn from the bar that the administrative time is really much more than we anticipated, and if we need to raise the fee, that we can at least revisit it. And I'm not sure if we as a group are going to exist after today, but that there be some mechanism for reviewing it in case the burden turns out to be large. But I like the idea starting with a low baseline.
Okay, Dolores?
I like the idea of charging as little as possible in light of the public comments that we heard or read, and seeing the hardships that many of the students are experiencing. My concern was setting the fee at the same price as a program in which the participants have less status, it concerns me because it doesn't differentiate. In other words, the student program that's set at $55 offers these students many less duties and even job opportunities than the current PPL program, the proposed PPL program. So to set the price exactly the same, to me, seems confusing. I think it would give the students in the other program, I don't know your acronyms, reason to say, why are we paying as much as these other students, other people who have more status and more job opportunities and more duties. So I would recommend cutting the baby in half and proposing $75, which would be still a bargain, $20 more, and it still differentiates between the two programs.
So certainly it's important, and I think we talked about the differences in terms of services that are available or work that would be done by the State Bar that would be over and above what is done for the PTLS program. I do want to focus, I do, you know, if you want to increase the fee, I think that needs to be the focus, for the reason because the cost should not exceed we should be charging what it costs to operate the program, not based on what benefit it is to the student outside of the cost to the State Bar to operate it. And so we did detail some of those additional costs, which can certainly justify something higher than the 55, if that's the direction that the committee wants to go in.
Okay, Paul Kramer has his hand up.
Question and a thought. First, the thought. I'm sympathetic to the dire financial straits that many of the applicants are in. However, because of the way the bar works, the money comes from somewhere else, and to the extent we significantly subsidize this program, we ultimately will, I suppose, be charging more either to bar members, or more likely the examinations fee will go up. So it's a zero-sum game here. My question was, last time I think somebody mentioned a $70,000 programming cost. Is that still part of the puzzle?
Yeah, that's that was to automate the process, to build it into our admissions information management system.
Okay, so that's a big chunk of money. That's going to have to come from somewhere. I don't have a strong opinion either way on the amount of the fee. I just want to point out that it is going to come from somebody else. It's not from the direct beneficiaries.
All right. Anyone else? It seems like there's been 3 proposals, 100, 75, and 55. Cindy, did I see a hand?
Yeah, I was just going to point out that these folks would be persons who if they, pass the bar, would be paying licensing fees. So we're actually possibly bringing in money for the bar that wouldn't otherwise come in, because we're bringing in at least something, because if they're not getting, they're not paying an attorney license, that's money we wouldn't be getting into the bar, because they decided not to take the bar exam and to wait off. But we're actually bringing in some funding for the bar by creating this provisional license program, that it's not coming in at the $400 or $500 licensing fees that we're charging those levels, but we're bringing in something that would otherwise not be coming in.
Rob.
Donna, I don't mean this to be an impolite question, even though it may sound like it. Did that was that $70,000 from, I'm starting to become more tech savvy as we all have to be depending on what sort of work we do. Did that come from a competitive bidding process, or do we have an in-house group that does it? It sounds, from what little I know, like a lot.
So we were working with an entity that helped us develop the system in the first place, and they've been working on some individual projects to improve the system. And so we didn't do a competitive bid for this one element, because they were absolutely the organization that would know best how to implement this one piece into the rest of the system that they developed on a quick turnaround basis. We explored doing it, the timeline that it would take to do it in-house, and the timeline was longer. And in the interest that we know to expedite this, we felt it was worth paying the outside firm to take this on.
Thanks for, that makes sense. Thank you.
Maybe you should call for a motion?
Yeah, any other comments before someone makes a motion? Well, so how about I throw something out on the table and see if folks are willing, someone's willing to make a motion on it. $75 fee with scaling for folks who are working with IOLTA funded organizations. So a 25% discount on that, which would make it $50, as well as no fee for folks who are working in a volunteer capacity.
I'll move that.
Eileen, this is Ruben. I'll second that.
Great. Did the motion come from Dolores?
Yes.
Great. So moved by Dolores, second by Ruben. Any discussion, comments? Okay. Ezra, could you call a vote, please?
Yes. Eileen Chin,
Yes.
Ruben Duran,
Yes.
Robert Barrett,
No.
Diane Boyer-Vine,
No.
Julie Chris,
Yes.
Terry Garland,
Abstain?
Dolores Heisinger,
Yes.
Jennifer Bacon-Henning,
Yes.
Judge Herman, Judge Herman?
Abstain?
Okay, thank you. Paul Kramer,
Yes.
Cindy Panuco,
No.
Judge Rodriguez,
Yes.
Angela Sierra,
No.
and Tiffany Townend Blacknell.
No.
There are 7 yes and 5 no.
Okay, the motion carries. Thank you guys for that discussion. Let's turn to the next item that drew a number of comments, which is with respect to the MPRE requirement. The comments on that start at page 15 of the document, and you'll see from the document that a number of commenters raised the, I think, very reasonable point that it may be difficult for folks to take the MPRE. It's still being offered. It's being offered in person. And I would propose that we make an amendment to our proposed rules to say that PLLs should take the first available MPRE if they haven't already done so. But in lieu of that, and until they've done so, they can satisfy that requirement by taking the 1.5 hours of ethics training that is in the new attorney training. And that they do so within their first year of being licensed as a PLL.
If that's the motion, I'll second it so we can have discussion.
I'm not sure that you meant 1 year, Highland, because everybody needs to take.
Oh, I'm sorry. Did I say 1 year?
Yeah.
1 month?
And so for everyone's information, the ethics portion of the 10-hour training, oh, I'll look it up again. I think it's an hour and a half.
A question.
Go ahead, Paul.
So if they don't pass this MPRE, what happens? For the bar exam, they can wait until the end of our programs live and continue to practice. But at a minimum, we need to be clear about this.
That's a good point. So your question is, if they were to take if they haven't yet taken the MPRE, and under this proposal, if they took the MPRE at some point during the duration of their PLL and didn't pass, what happens?
So just 2 points. One clarification: the legal ethics is 10 hours. I'm sorry, 4 hours of the 10-hour requirement. And so the proposal would be that they have to take those 4 hours within a short period of time. And I think the question is really the comparison is, right, this is instead of requiring them to take it before they apply, we'd be saying they would have the ability to take it, to take and pass it after they've applied for the program. But one of your options is certainly to treat it like moral character, in that if they were to get a negative moral character determination during the process, then they would be suspended or terminated from the program. You could approach the MPRE the same way. They've got the option to take it. If they don't take it in the first offering of it, they can take the 4 hours of legal ethics. If they choose to take it and they fail, then they could be suspended from the program until such time as they pass it.
That sounds kind of draconian, and it would encourage people not to take it at all. How about making them retake it at the next opportunity that it's offered? That still is a disincentive to take it at all.
Isn't the MPRE something that people, if they were expecting to pass the bar in July, would have crossed off their list by now?
So it's certainly common that if you were planning on a July bar, you would have taken the, March, probably taken the March MPRE. I certainly cannot give you percentages on how many people do that. But, mid-March was, I think the MPRE was offered in March on like the 12th or the 13th of March, which is right about when the safer at home orders were going into place. And so people may very well have may have been signed up and just not gone.
And the next offering after that was in August, this past August.
So then the question, I guess, is passing the MPRE assumed to be indicative of understanding the rules of ethics more important in providing public protection than having passed the bar exam? In which case, you may not want to treat it the same way. If it's not, maybe we should just treat it as we do the bar exam, that they don't need it until after they've passed the bar exam and they want to get sworn in as a full member of the bar.
That would certainly simplify matters.
It would. This is Judge Herman. It would simplify matters, but really, that's for public protection. The ethics piece is really pretty core. I mean, in terms of, one, the opportunity to take it prior to even graduating, and two, just the idea that for public protection that we should have some confidence that the applicants have at least passed the exam, or worst case, take it the first opportunity they have after they've applied. It's just my thinking.
Does it give you any more confidence if we treat it as taking the bar, but we still require them to take the 4 hours of training?
Well, I don't know that 4 hours of training, I mean, I'm assuming that most of them as law students have taken professional responsibility, but I don't know that the 4 hours of training really is a substitute for having some confidence that they've been examined and passed. Anyway, that's my thought.
Okay, there's a number of hands raised, so let's go in order. Dolores, and then Ruben, then Jennifer, then Terry. So Dolores, please go ahead.
It's my understanding that the pass rate for the MPRE is very high, that there are very few people that don't pass it. So if that's true, it seems to me it's important for them to take it and pass it, and if they don't pass it, to be terminated from this program.
Thank you, Ruben.
Thanks, Eileen. First of all, I agree with Dolores that I think the pass rate is very high. It's an important exam, but it's relatively easy to pass. The distinction I wanted to draw to the comments previously was that these folks, PLLs, are going to be practicing for a year plus, at least, right? So I don't necessarily equate it from an ethics protection standpoint as the same as passing the bar exam. I think a distinct requirement that at least taking the hours of training is a way to sort of meet the middle ground. The fact is there are folks who either won't take it or couldn't take it because of the pandemic, and I think that this is a reasonable middle ground. I just don't think we should ignore the requirement.
Thanks. Go ahead, Jennifer.
Yeah, I guess I'm just struck too that these folks will be under a supervising attorney for the entire time that they're part of the program. So, in terms of the public protection piece, you have that overlay of the supervising attorney who will really suffer consequences if their attorney underneath them acts in an unethical manner in violation of the rules. And, given the uncertainty and the fact that these tests right now are only being offered in person, I'm sort of inclined to swing towards treating it the same as the bar exam and coupling it with the supervision and the 4 hours of training taken within a month, as you suggested.
Thanks. Go ahead, Terry.
I had a question and a comment. So the question is, I'm not sure about the in lieu of part of it. Are we saying, is the proposal that they could take and pass the exam, or in lieu of that, take the educational requirement? Is that the proposal?
Yes.
Okay.
Either, right. If they should take and pass the exam, or if they haven't, for whatever reason, they could satisfy the requirement by making sure they do the 4 hours of ethics within the first month of their being a PLL.
Okay. All right, thanks. And then, on the comment is that although I am always a strong supporter of ethics education and competence, particularly in ethics, the thing that gives me pause here is that hearing that the MPRE is not available except in person. And I am concerned about that right now, given the situation health-wise of what we would be asking people to do. So if it were available remotely, then I would have no problem saying they should take and pass it as a condition of remaining in the program. But given that it's not available remotely, then I hesitate on that.
Thanks, Terry. And that's the motivating force behind my proposal to have the in lieu of component. Notwithstanding the argument that was quoted back to me by a public commenter that I made in the case where I represented the University of California, I'm very sympathetic to people who are immunocompromised or who, for whatever reason, cannot access an in-person exam during the pandemic. The part that was quoted back was a very technical associational standing argument that I made. And so for that reason, even though I think it's very important to have passed the MPRE, we should have, an alternative way of satisfying that requirement. I think Judge Rodriguez, you had your hand raised briefly, but I don't see it up anymore.
Yeah, I lowered my hand. I think my views have been covered by many of the people that have already spoken. I like Paul's idea. If the MPRE is still the same as it was when I took it, I do remember that of all the hurdles that one has to overcome to become a licensed attorney, the MPRE was probably one of the easiest. It's, I believe it was a 2-hour exam. It's all multiple choice, and it doesn't have a very high pass rate from what I understand. I echo the comments that these provisionally licensed attorneys are going to be supervised. So I like the in lieu proposal. That's all.
Okay, any comments about what to do about if someone takes and doesn't pass the exam during the pendency of the PLL period?
This is Judge Herman, not on that point, but I think I am persuaded in relation to taking the exam, given the COVID-19 issues of it being required in person.
Helen, on your point regarding if they take it and don't pass it, I think they should still be allowed to have to do the in lieu. If we're going to let someone who's never taken it at all to do it in lieu, then we should let it for somebody who's not passed it, because I teach the course in professional responsibility. I know an awful lot about this exam and my students' experiences with it. It's part of the requirement, so there's no point in debating whether you can really test somebody's ethics on a multiple choice exam, but I think the in lieu option would solve that problem.
Okay, I'm also persuaded by the point that Jennifer made, which is that these folks are under supervision by somebody who is going to be professionally responsible for their decisions. Terry, and then Judge Rodriguez, and then Jennifer. And Ruben, I can't tell if your hand is new or old.
It's old, I'll take it down.
I also would not penalize folks for taking and failing for a few reasons. In addition to the supervision, also, people who are taking it during this period will be doing it in person during very difficult circumstances. And that's an additional burden that people don't ordinarily have. So if they fail under those circumstances, it may be for things completely unrelated to their knowledge of the ethics requirements. Also, I would want to encourage people to take the exam for the additional reason that there's a benefit to studying it. I mean, to thinking about it and studying legal ethics, there's knowledge that is gained there, and I want to encourage them to do that sooner rather than later.
Great, thanks. Judge Rodriguez?
Well, currently, it's my understanding that if they become provisionally licensed and they take but fail one of the bar exams that's offered during this provisional period, that does not revoke their provisional licensure status. So I don't think it makes sense to revoke that status simply because they failed the MPRE. If we're not going to take it away if they failed the bar exam. I don't think that makes any sense.
Okay, Jennifer?
That was the question I was just going to ask. I couldn't recall how we resolved that, but I don't think that the MPRE should be more restrictive than whatever we decided on the bar exam.
Okay, so sounds like folks are, we've discussed the proposal on the table to have the, if folks don't have an MPRE passage, to allow them to satisfy that requirement through making sure they take the 4 hours of ethics that's in the new attorney training within the first month of their being licensed as a PLL. The PLL will not be affected by attempts to take the MPRE and failing it during that period. I think Rob made the motion. Do we have a second?
I'll second.
Thank you, Judge Rodriguez. Ezra, could you call a vote, please?
I'm sorry, can I just clarify for a second? So I'm 100% certain what we're drafting. So if they have not taken and passed the MPRE before they apply, what I missed was if the motion included a requirement, the option that they take it at the first available, and or take the 4 hours of the new attorney training within the first month, or if we just said if at the beginning, if you haven't already taken it, by the time you apply, then within the first month of you becoming a PLL, you have to do the 4-hour training, and you should take the MPRE at some point during the term, but if you don't pass it, that's okay.
That sounds more administratively convenient.
Yeah.
Okay. So either so then we're saying if you haven't taken it and passed it by the time you signed up, no problem. You have to within the first month of your licensure, your provisional licensure, and I will add the caveat of or the program becoming available, because it may not be available on day one of the licensure, since we have to automate the availability for those folks. Then you have to take those 4 hours within that first month, and not terminated from the program for any MPRE failures that may happen during the time of the program.
Okay. We're ready for a vote.
Highland Chin,
Yes.
Ruben Duran,
Yes.
Robert Barrett,
Yes.
Diane Boyer-Vine,
Yes.
Julie Chris,
Yes.
Terry Garland,
Yes.
Dolores Heisinger,
Yes.
Jennifer Bacon-Henning,
Yes.
Judge Herman,
Yes.
Paul Kramer,
Yes.
Cindy Panuco,
Yes.
Judge Rodriguez,
Yes.
Angela Sierra,
Yes.
Tiffany Townend Blacknell,
Yes.
Great, thanks. Okay, next up is a comment that appears on page 5 of the document asking for clarification. And I think this is a fairly non-controversial one. It just asks that we clarify that applicants for the PLL need not have passed the bar exam and need not have sat for the bar exam. So there was a question posed as to, it's unclear as to whether you need to have sat for the bar exam. And I think based on our discussions, we all agree that you need not have sat for the bar exam either. Folks seem to be good with that. So we can make that clarification in the rule, so there's no ambiguity.
We need a motion.
Why don't we couple this with the next item, because I think that we can get through that one quickly as well. Okay, so the next item, and we can take a vote on this all together, shows up on page 25 of the comment chart. There was a question as to whether the supervising attorney, there's a requirement that they have actively practiced law for a period of time. There was a question as to whether that also includes having taught law at a California law school. And I think it should include that. I mean, the question is, I think we all thought that was already part of it, but perhaps we need to make that explicit. Because I remember one of us asked Greg or Neil a question as to what it means to be, you know, actively practicing law. And it really just is, are you an active member of the state bar? So that should include someone who's an active member of the state bar and who is taught at a California law school for a period of time. Discussion, objections, comments? Folks are shaking their head. Okay, so do we have a motion to make those two changes?
Move it.
So moved, Duran.
I think Diane has the motion. Ruben, will you second?
Yes.
Great. Ezra, could you call a vote, please?
Hyland Chin,
Yes.
Ruben Duran,
Yes.
Robert Barrett,
Yes.
Diane Boyer-Vine,
Yes.
Julie Crisp,
Yes.
Carrie Garland,
Yes.
Dolores Heisinger,
Yes.
Jennifer Bacon-Henning,
Yes.
Judge Herman.
Yes.
Thank you. Paul Kramer,
Yes.
Cindy Panuco,
Yes.
Judge Rodriguez,
Yes.
Angela Sierra,
Yes.
Tiffany Townend Blacknell.
Yes.
Thank you.
Great. Next up is an item, so on page 25, there have been raised a number of questions about where somebody should be located when they're practicing. Is that right, Donna? Do I have that right?
Yes. So the question was whether
The office, having the office in California?
Right. So we require not that the PLL or even the supervising lawyer are located in California, but that they are working for a firm, as we've very broadly defined that term, that has an office location in California. Not that that's where its headquarters are, but that it has an office location. And there was a comment that was made by an individual who is proposing to work. I think this, if memory serves, the individual is proposing to work, in South Korea for California licensed lawyers, but although they had offices, may or may not have had offices in the United States, they didn't have an office in California. So that was sort of the question of whether or not we can eliminate that office in California requirement. We did copy that office in California requirement from the Registered In-House Counsel program. That's where that came from.
And then I think we can also consider this comment together with the comment about the location of the supervising lawyer. So I think there were some comments about the supervising lawyer needing to be present in California.
Yeah, I think that's already not required under the rule.
Okay, so we just needed to make that clarification that's not required. Okay. All right, any discussion on office needing an office located in California? Diane?
I have a question for Donna. Why is that requirement in the other program you mentioned, Donna? Do you know?
Yeah, see, I knew somebody like you would ask me that question, Diane. I don't have the answer off the top of my head, but I suspect the point was for Registered In-House Counsel, the reason that, and you can make this very same argument here, you're getting sort of a special admittance to the California bar for the purpose of practicing California law. And so it would seem that there would be an office in California. I think Amy may have some more better background memory on that than I, but that would be my guess.
Yes, I think that's it. It's that we needed to ensure that it was a practice that was in California. It was a California organization because the law that we're overseeing is California law. Excuse my voice. So yes.
Go ahead, Terry,
Mhm.
and then Angela.
Yeah, I'm just curious if neither the employing firm nor the PLL has to have an office in California. Does that mean that, let's say you're in a state that doesn't have a provisional licensing program or you don't meet the rules of it, you decided to apply to the California program? And if so, does California want that?
Right, and certainly all we can give you is the right to practice California law. And so that's also what went into that sort of question of if you're not in California, are you practicing California law? I think there's certainly an argument with the society even before COVID and the extra level of remoteness that we have, that people are practicing law all over, regardless of where their office may be situated, and if they're supervised by California licensed attorneys in California law, that may be fine. We cannot authorize them to practice law of any kind, provisionally or otherwise, in any other jurisdiction other than California.
Angela?
Yeah, I mean, this is something I'm struggling with a little bit, just because, I'm not sure, whether there may be unintended consequences, to expanding this, including having PLLs not be in California. And is it going to be, is there unintended consequences on residents of California, law students in California that were intending to practice here? And so I'm wondering if anybody has thoughts of could this really kind of change the nature of the practice for this group?
Well, I guess one question is whether if the supervising attorney has to be a California licensed lawyer, to what extent those folks are just randomly out in the world someplace other than California. And
yeah,
I don't know if we know.
Yeah, I just don't know if we know that.
Yeah.
It's very unusual, I think. I mean, there may be, specific circumstances, isolated circumstances where folks, both the, line attorney or the supervisor is out of state, but I would think that would be the exception. And whether this is going to change that quite a bit.
I know this is only anecdotal, but I'm a California licensed attorney in Chicago. So I'm out in the wild, I guess you would say, under that. And I encounter quite a few California licensed attorneys around the world because I do programs that qualify for CLE, and we send out the certificates to them for California. So folks are out there. I guess the issue is I'm just trying to think about the circumstances in which, so you're not in California, your supervisor isn't, your PLL isn't, but you would be practicing California law. Because as pointed out earlier, that's the only thing that can be authorized under this. I guess it happens, but I do have a little bit of concern about unintended consequences too.
Yeah, and I also I think it was a point that Greg may have raised in one of our earlier meetings that this is perhaps one of the least restrictive schemes amongst all the jurisdictions that do have a provisional licensing program. Neil?
So let me just ask, if the supervising attorney doesn't have an office in California, what does that pose in terms of regulation and maybe enforcing possible discipline? What does that mean? If how does that complicate that issue?
That attorney would still be subject to the jurisdiction of the state bar, right? Regardless of whether they are physically present in California.
That is correct. That is correct. We do reach California licensed attorneys through the discipline system, even if they reside in other states.
Okay.
And I think, I I understand the reservations. I'm thinking through this now as well, but really the regulatory hook here is that supervising attorney's California license. We do have California licensed attorneys practicing California law outside the state.
Diane, and then Cindy also has her hand raised.
I'm going to show my ignorance. Putting aside regulating the attorneys, for a malpractice lawsuit against the attorney in the firm, would you have to have that physical presence in the state just to even serve them with the lawsuit? I don't know that area at all. Hopefully
Yeah,
somebody
there
else
might be a
does.
personal jurisdiction issue.
Right, that's the unintended consequence I'm worried about.
If I can hazard a guess, because that's the other subject I teach, civil procedure, and I would say, yes, you could get them here quite easily.
Cindy?
That was my question too. I think one of the commenters was specifically raising working in South Korea. So then there's the further issue of not just having jurisdiction over them in another state, but one of the comments specifically asked about being out of the country in another country, working with firms or licensed California practitioners in other countries. So whatever we do, we probably have to address whether it reaches that too.
Yeah, I think I oversimplified my civil procedure hypothetical, because it's one thing to get a judgment, it's another thing to enforce it.
Other comments, thoughts?
So I guess the question then is there a motion to either amend this or to leave it as is?
I would move to leave it as is.
That's where I'm leaning as well. It does raise, especially given the recent U.S. Supreme Court decisions on specific jurisdiction, it as you raised, the malpractice suit could be difficult to file.
So if that was a motion from Diane?
I'll second that.
Great. Ezra, could you call it, or sorry, any discussion before we call a vote?
Can we please just restate the motion?
The question was to leave the proposed regulation as is and not add the requested change regarding physical presence at the office.
Thank you.
Do you need a motion for that?
Yeah, I don't know. Do we, Donna? I don't.
Probably not technically, but because we've spent time talking about it, I thought it would just be good to have a formal record that we talked about it and decided not to change it.
Okay.
Roll call.
Yes, please.
Hyland Chen,
Yes.
Ruben Duran,
Yes.
Robert Barrett,
Yes.
Diane Boyer-Vine,
Yes.
Julie Chris,
Yes.
Terry Garland,
Yes.
Dolores Heisinger,
Yes.
Jennifer Bacon-Henning,
Yes.
Judge Herman,
Yes.
Paul Kramer,
Yes.
Cindy Panuco,
Yes.
Judge Rodriguez,
Yes.
Angela Sierra,
Yes.
Tiffany Townend Blacknell.
Yes.
Thank you.
Great, thank you. So another item that appears on page 25 of the document is one commenter talked about, raised, I think, in my view, a reasonable, proposal that PLLs be allowed to have multiple supervisors across different firms. We've talked about having multiple supervisors from within the same firm, but there could be situations where somebody needs to be supervised by a family law practitioner from one firm and perhaps somebody who specializes in a different area from a different firm. And so I think, we should consider making that change to the rules to make it clear that that's an acceptable form of supervision. Any discussion? Does someone want to make a motion?
So moved.
Second.
Motion from Jennifer and second from Paul. Any discussion? Okay, Ezra, can you call a vote?
Helen Chin,
Yes.
Ruben Duran,
Yes.
Rob Barrett,
Yes.
Diane Boyer-Vine,
Yes.
Julie Crisp,
Yes.
Terry Garland,
Yes.
Dolores Heisinger, Dolores?
Yes.
Oh, thank
Right.
you. That's okay. Jennifer Bacon-Henning,
Yes.
Judge Herman,
Yes.
Paul Kramer,
Yes.
Cindy Panucco,
Yes.
Judge Rodriguez,
Yes.
Angela Sierra,
Yes.
Tiffany Townend Blacknell.
Yes.
Thank you.
Great. So one other item that comes through a number of times in the comments is the item that we spent a bunch of time discussing, which is requiring that somebody have a supervisor in place as part of their application for a PLL. And we talked about the administrative burden it would place to have two different steps. I do really take the concerns raised, though. It sounds like what we would need to do is some very clear education around the PLL program so that employers know that a PLL, will be issued pretty easily. And I think we should provide just communications to the entire state bar membership, perhaps through a mass email, about the provisional licensing program so that employers know that this is something where they can hire someone and be that person's supervisor, and that person can get a license. And perhaps we could also work with the California Lawyers Association to have them put together some information sessions around the program. Wanted to raise this for discussion if anyone has thoughts, comments, based on what we saw in the public comment. Tiffany?
Do we know how soon these provisions will be released? I'm having conversations with our management about the program and about potentially hiring imminently. And it came up recently that we cannot post a job bulletin which lists this as one of the possible requirements unless we know for sure the details of the program and can list them in the bulletin. So do we know a time frame in which these things will be finalized?
So yeah, we're working as fast as we can, right? The issue is, and we're going to end when we end today's meeting. The question will be: does this need to go, in light of the changes that the group is making? Does this need to go out for a second public comment or not? If not, it can proceed to the Board of Trustees for approval. We've put it on the agenda for next week's meeting in case we're able to do that. If it gets approved by the board next week on the 24th, we will ship it over to the Supreme Court for the Supreme Court's adoption right away. But then we do, assuming the Supreme Court, when we get the Supreme Court's adoption, we have done much of the automation, but there are things that can't be done until we nail down all the requirements. And so there will have to be a period of time after we nail down the final rule in order to finalize the automation. So those are the things impacting the timeline.
So, Donna, assuming that this can go straight to the board for approval at the end of next week, what's your best guess as to when, assuming the rules stay in relatively the same form?
So Neil or Greg, you'd need to tell me the court process in terms of, is it, the September administrative conference, or what's the process for the court's consideration of the rule?
It could be a couple different ways. It could be done as soon as possible issue, or it could be depending on whether or not we wind up doing another round of public comment, whether it could be the October admin conference, which is usually the third week of the month.
And then Amy, I'm sure you've been in greater touch with the process of automating the requirements that we have so far. Do you have a sense of timeline once we have finality of the rule, how long the finalizing the automation will take?
Yes, so we could be done with the automation, given the changes I've heard today. If they were approved, we could probably be done with automation by the end of October. We could safely say that.
Okay. Ruben and Cindy, I can't tell if the hands that you have raised are new or old.
That's old, sorry.
Okay, no worries. Okay, any consideration of other changes based on public comment? Are there items that folks on the working group want to raise?
Highland, there was just one more that was raised in the staff comment, and it's a technical one.
Okay.
On page 6 of the chart, we'll obviously need to. There was a clarification on what completion of the new attorney training within the first year meant.
Okay.
I didn't think it was necessarily confusing, but if it was, and there was any concern that it meant by the end of 2020, that's an easy clarification to say by the end of the first 12 months.
Got it. Okay. Anything else? Neil, you have a hand raised?
Yeah, I know that this was technically outside the charge of the court's July letter, but July was 2 months ago, and I don't know about you folks, every month seems like a year these days. And it's also was before the court made its decision about retroactivity. So I want to open up the idea of maybe allowing folks that previously scored a 1390 or higher into this group. And I'm sorry you're doing this in the last 4 minutes of the meeting, but just raising that, I can't make any promises about what the court would actually do, but I'm just sort of speaking for myself. Having as much options out there as possible, I think is the best strategy here for everybody involved, and especially for these folks that are trying to get out there and start working.
So it would be a recommendation from this working group to make it retroactive for the folks who scored 1390 or above?
What it would be is, I see some of the comments suggesting this idea that folks that have scored at least a 1390 or between 1390 and 1439 be admitted into this program, and that once the program ends, if they've successfully completed it, they can be admitted without having to take an exam.
I don't think we have enough time for this discussion, but go ahead, Paul.
I wanted Neil to repeat that last part.
Sorry, no, so some of the commenters had this idea of saying, opening the program up to folks that scored between 1390 and 1439, that they can enter this program, and then can complete the program without, and then enter the profession without taking an exam.
Wow, yeah, that's more than 4 minutes worth.
How far back? Retroactive to when?
That's a good question. That was a subject of debate when the issue was before the court about applying immediate retroactivity, right? 5 years, 3 years, 2 years. Again, I can't speak on behalf of the court. I don't know what the court would do, but certainly it would, be fine to consider any one of those ranges, I would think, for this kind of program.
So I just want to raise a process point, which is I know there are a number of people, including me, who have a hard stop at 11.
Okay.
I need to jump from this to running a meeting at my firm. I do wonder whether, this is going to be a broader discussion. I know everyone's got their hands raised and wants to comment. What about the process for the rules as they stand now? Could we separate out, let's get those rules in motion, get those through whatever process they need, whether it's for additional public comment or whether it can go straight to a vote from the Board of Trustees and then to the Supreme Court. And can we separate out this retroactivity issue and have a different meeting on that?
It could be a separate rule that just simply refers to this rule.
Yeah. Okay. And then as to the question about do these rules as revised based on our discussions today and votes today, do those need to go out for another round of public comment?
I don't think we've made any huge significant changes here, right? So probably not.
No, we have reduced the fee. We have made the change about MPRE not needing it for eligibility for the program. And then a couple of minor clarifications. And the multiple different supervisors at different firms. That's what we've done here.
Okay. So I propose that we set another meeting to discuss Neil's proposal. Every time we have a meeting, we say this is going to be the last one.
I have a
Angela?
quick question. I like that idea a lot. And with respect to the proposal, could that conversation even be broader? Into folks that didn't have an opportunity to take the bar, a year ago for other reasons, or or this program should be more broadly applied.
I think, again, that's going to be subject to the wise discussion of this group, right? So yeah. Another reason why we need to have a separate meeting on this.
Yeah. Okay.
Okay.
I like the idea, Highland, that we submit this rule to the board and then with the board's approval to the Supreme Court, we reconvene this group for another meeting to talk about the issue of limitation on to 2020 law grads, whether the 1390 or others, and then we would propose another rule potentially that could expand.
And that refers back.
Yeah, and it would expand. It could expand the program that way.
Okay. All right. I do have to drop because I have to lead a meeting at my firm now, but thank you to everyone again for your time and all of the care and attention you have given to this really important issue.
Thank you.
All right. Thanks, everyone.
Move this to the. Donna, do we need a motion to move it to the board?
No. So the motions to amend is what we needed. And so that was just a process clarification question.
Okay, we can all jump off the call then.
Yes, you are free to jump off the call. Thank you so much.
You.
Very helpful.
Right.
Donna, how are we going to go about with this subsequent meeting?
We will send you out a doodle poll or something like that to request availability for another meeting. We'll have a little bit more flexibility in terms of time and dates because we were really working under this pressure crunch in hopes to be able to move a draft rule forward. So since we have that rule and this would be kind of an addendum to that, we can find some greater flexibility for dates.
Sounds good. Thank you.
Thank you, everybody.